One second, we are just going live, Prashant. So I will make a quick introduction. Okay. Uh, Sorry. Hi everyone. Sorry. Welcome to this webinar on intercorporate loans and also on project finance. With me, we have here Prashanth Sabeshan. He is a partner at Majmudar and Co. in Bangalore, and he specializes in debt finance and project finance, loans and borrowings. Today's outline for the webinar is we are going to discuss the new provision in the Companies Act 2013, which places restrictions on lending between companies. We're also going to take a look at what kind of security documentation is required by lenders and what are the sources of funding options that companies have. And at the end, we will look at a standard project finance structure to understand how project financing works. Uh, I will I will hand over the stage to Prashanth to continue from here. We will have this will be an interactive discussion, and if you have any questions, please feel free to email us at startup@ipleaders.in or WhatsApp us on my number 9717301797. I'm going to ask Prashanth the question on your behalf. So feel free to ask these questions at any stage in the webinar. Prashanth, thank you for agreeing to take this webinar. Uh, we'll start with the introduction, maybe on the intercorporate loans, and first a little bit about yourself. You know, if I've missed out on anything relevant regarding your practice areas, you could let us know. Maybe.
Sure. I just wanted to make sure, is the voice clarity okay?
Yeah, it's all right.
Okay. Thanks, Abhijit, for this.
I hear some noise actually, Prashant. When you speak, there is some kind of noise. Maybe you want to adjust the mic a little.
Yeah. Is it any better now?
It's a bit distorted. All right, let's continue. We'll see.
Okay. Thanks for this opportunity. Yes, my essential background is in the area of financing and infrastructure. So I completed law from National Law School in '97, and then have been practicing with various firms. Started off in Bombay and then worked abroad for a few years. I have been in Bangalore for the last about 3 years now with Majmudar, and so I wanted to speak about this practice area with the people who are attending this webinar. So to begin with, as you know, the Companies Act has.
Prashant, I'm extremely sorry to interrupt. There's a lot of. I think the wires are catching some disturbance. Okay, when they get in contact with maybe a piece of material somewhere, like maybe your hand is touching it. If we can just try reconfiguring it for a minute, or we can shift to your on laptop mic.
Sure.
I'm extremely sorry about it, but yeah, let's just try it for 10 seconds. Yeah, can we do a quick test? Yeah.
Sure. So do you want me to switch off the mic?
No, this is perfect. Now it's fine.
Okay. So I'll just continue. Do let me know if there's a problem with the voice.
Right.
So to begin with, I thought we'll look at the new.
I'm sorry. I think there is a problem. Can we configure your your laptop mic?
Okay. Sure.
From the settings, the gear toolbar in Google, on top.
Yeah. Sure.
Sorry guys, we're just trying to fix this so that it will be better. You can hear better audio quality from all of us. In the meanwhile, if you have any questions, please feel free to send us on my number 9717301797. We will be discussing largely sections 185 to 186 of the Companies Act and separately project finance structures and documentation. Yeah, Prashant.
So there is I just want to this jack mic and microphone array. So and default.
If you can configure your inbuilt mic, we can try that. Hello? Yeah, I can't hear you anymore. Just your inbuilt mic with headphones. In the meanwhile, I will just put up on the screen a structure of a project finance documentation. It might be useful as reference purpose for all of you. Yes, Prashant. Prashant? Yeah, Prashant, you there? Okay, it's not working. The mic is not working.
Yeah, hello, hello.
Yeah, fine.
Can you hear me now?
Perfect.
Okay, okay,
Yeah, so
okay,
now it's
sure.
perfect. Yeah, let's continue with this. Sorry guys for the minor snag. We will now continue with the webinar.
Yeah, so just to step back. So the so I was just wanted to
Oh my god. Yeah,
yeah, I just wanted to focus on the new provisions under the new Companies Act on intercorporate loans, and what does it mean for companies at a practical level. And also, interestingly, what have the rules done? So, if I can just quickly take you through, 186 to begin with, and I'm not going to read line by line, but essentially 186 talks about investments. How many levels of investment companies can you have, and then there is an exception of proviso which says when you don't need to follow this. That is 186.1. 186.2 says that you can give a loan or a guarantee or provide security as long as you're within 60% of your paid up share capital of free reserves and securities premium account, or 100% of your free reserves and securities premium account. And if you're exceeding this, you need a special resolution. So I'll just stop for a minute here. And what this is important, why this is important is, now this is the main section, but I'd also request you to look at rules, rule 11 of the Companies Act rules.
okay.
It's the company meeting of board and its powers rules 2014. So if you can look at rule 11.
So we haven't asked them to carry the rules right now, but we
No,
will
I'll read it out. I'll read it
just,
out.
yeah. Okay.
All that rule 11 does is that where a loan or guarantee is given or security has been provided to a wholly owned subsidiary or a joint venture company, or acquisition is made by a holding company by a subscription, purchase, or otherwise, of the securities of its wholly owned subsidiary, the requirement of subsection 3 of 186 shall not apply. Okay. Now, if you just go back to section 186.3, 186.3 says, when do you need a special resolution? I need a special resolution when I'm exceeding, 60% of let's call it net worth.
Right.
Okay, so I before we get into the details, I just wanted to point out that this is one instance where the rules have been used, to actually supersede the act. Because what Rule 11 does is Rule 11 says that if you're giving this loan or guarantee or security to a wholly owned subsidiary or a joint venture company, then you don't have to comply with the special resolution even if you're exceeding 60%. So from a practical point of view, what happens is, in case of group companies or intercorporate loans, if I've set up a wholly owned subsidiary or joint venture, I can actually exceed 60% of my net worth, and overcome the requirements of 186(3) by giving that loan or guarantee or security to a wholly owned subsidiary or a joint venture company.
Right.
So this is a very useful practical tool, and more importantly, so the rules have actually amended the act. Normally we learn sort of in a legal classroom that delegated legislation, should not overcome the rules of the main legislation. But this is one instance where delegated legislation have actually tried to go beyond the realm of the main legislation. And it's interesting because this, if this is the practice which is being followed, then at a practical level, the guys who are passing the rules are a lot more in control of what is going on under the act than the sort of the MCA guys who are drafting the act. So just
Right.
to give you the background to what corporate intercorporate loans I can give, I can give
Prashant,
it
if you
to the.
can move backwards, I think you there was no feedback coming. The sound gets better if you just lean backwards.
Yeah. So can you hear me?
Yeah.
Yeah. So I just wanted to spell out that at a practical level, if you look at what are the type of intercorporate loans I can give, this allows me to give loans to wholly owned subsidiaries or joint venture companies, and the benefit I have is that I don't have to comply with the special resolution requirements. So this is helpful for companies who are
Right.
looking for funding, and who need resources and cannot go to the market to access funds.
Just a
Hello.
little question here, Prashant.
Sure, sure.
The section, yes, the section is exempting holding companies, holding subsidiary loans, and fully owned subsidiary loans, right? And it also says joint venture companies. Now, joint venture would mean any company where there is, invest. So joint venture would not require a holding subsidiary relationship. It just means any incorporated venture where there are two more
Yes,
companies,
yes, yes. I think
right?
it has been, yeah. It because the way it is quite a liberal, definition of joint venture, where you correctly pointed out, there is no specific, uh, amount of shareholding which is required in the joint venture. So it is quite open, and even minimum
Right.
shareholding should suffice. So this helps. This will help company structure the number of their operations, and enable them to sort of provide these intercorporate loans.
Right.
Okay, and so another area where this is helpful is when you want to provide intercorporate loans on a cross-border basis. So then you can go ahead and use this provision also, under those circumstances where, when I say cross-border, it's a situation where the company with the money, let us call him the lender company. The lender company is based in India, and the borrowing company is based outside India, and the lending company can go ahead and give a loan to its group company under this provision.
Which is the company which is outside India?
So the borrowing company. Hello.
Yes,
Hello.
yes.
Yeah, can you hear me?
I'm there. Yeah.
Yeah, so the borrowing company which is based outside India, So the lending company or the borrowing company can go ahead and have a transaction or provide an intercorporate loan or provide a guarantee. Uh, and this is a useful provision from that context also. So you're not hit by the
Okay.
60% rule or the special resolution rule in that case also.
Okay. Can you give an example of this?
Yeah, so this happens quite common. For example, tomorrow if we have large promoter groups in India who are setting
Okay.
up who are acquiring assets outside India or setting up companies to acquire assets outside India. So many times when you want to acquire an asset, some portion of the money has to come in the form of equity. Hello.
Right.
Yeah, so
Yes,
uh,
yes, we're
so
there.
yeah, so in order to fund the initial capital of the company, the equity, capital of the company, that money which has to come from the Indian promoters, can come in the way of equity or even an intercorporate loan.
Right.
So this is one area where it is used a lot by corporates, on a day-to-day level where they have to acquire overseas assets, or their manufacturing units and things like that at a cross-border level.
Right. In that case, they do not require to comply with this 60%
Yes,
provision.
if you're meeting the if you're meeting the wholly owned subsidiary or the joint venture requirement,
Right.
then you still have to uh,
Comply with it.
comply with the net worth, but you have the benefit of of the other two provisions. Now I'll just take you to the proviso for a minute.
Right.
Proviso to 186(1) says that this provision of this subsection shall not affect a company from acquiring any other company incorporated outside India if such company has investment subsidiaries beyond two layers.
Right.
Right, or it says a subsidiary company from having an investment company for purpose of meeting requirements under any law or regulation framed under any law for the time being in force. So
Right.
this also helps set up overseas investment companies if the laws of the we call it the host country allow you to set up those
Right.
companies. So if the laws of the host country
Okay.
allow you to do it, as long as you meet the net worth requirements, then you can go ahead and provide these intercorporate loans or guarantees.
Okay. So let me quickly sum up the discussion till here, and then we can take it forward. The first point is that um, that that any company can give loans or uh, or acquire shares in another company until 60% up till 60% of its net worth. This provision does not apply to joint venture companies, to any loans given to joint venture companies, doesn't apply to holding subsidiary relationship companies, for example, where a loan is given by a holding company to a subsidiary, or to companies where the subsidiary is entirely wholly owned. Uh, Next part is where a company has an offshore subsidiary. In that case, once again, the law says that no company shall make investments through more than two layers of companies, of investment companies. However, there is an exception that where the laws of the other country, in case of an international transaction where the laws of the other country uh, allow you to have another layer or require having a special investment vehicle for that. In that case, this restriction does not apply. Is that correct, Prashant?
Yes, yes, yeah, I think that's fine. Yeah. So I wanted to just clarify that this is the provisions under the Companies Act.
Right,
There will also be the FEMA rules which will apply to a cross-border financing structure.
right.
So we could take it up later, if
Okay, I just had a question. Do you have any examples of, could you state any examples where the law of a foreign country has required additional layers? So eventually, as a result, what happens is that the Indian company is investing through more than two layers. You have any examples of that?
Yeah, so we did a transaction where an Indian promoter was giving a guarantee uh, to its Australian subsidiary, but
Okay.
that was the third level subsidiary, not the second level. That is, so to give you a structure, there was the Indian promoter, then there was one Singapore holding company, there was another Singapore holding company, and then the third
Right.
one was the asset company or the operating company.
Okay.
So now, the it was more than two layers,
Right.
but the law in of the host country, allowed that company to be set up as an operating company and attract investments from more than two layers above. So the so
Right.
the so the in the in so the Indian promoter could directly, give a loan or a guarantee to the Australian company, even though he had two levels of holding companies, because the local law, allowed him to do so.
Okay.
Yeah, this I mean to just so this host country, for example, was in Australia.
This
And
limit of two layers applies. Just a question, Prashant. This limit of two layers applies only to investment, or does it also apply to loans or guarantees?
no,
Because the
so
section says investment.
yeah, no. So the no. So just to clarify, so that is something which actually, to be honest, we are still debating a bit, because the section says
Okay.
investment,
Right.
whereas if you look at subsection 2, it says, I can give a loan and guarantee to anybody as long as I'm within 60%.
Yeah.
And investment company is, if you look at subsection 12, 12.1,
Yeah.
that is 186 12.1, sorry, 186 13a, sorry,
Yeah.
which it defines investment company, as a company whose principal business is acquisition of shares, debentures, or other securities.
Mm-hmm.
So I mean, if we take a view that that 186 one applies only to investment companies, then it will exclude, loans and guarantees. Then loans and guarantees will be available only to
Yes.
wholly owned subsidiaries or joint venture companies. So
Okay.
that is I mean, the reason I'm telling you there is a debate is because the Reserve Bank, FEMA regulations allow you to invest up to two levels of companies,
Right.
uh, right? And we
The
just wondering.
overseas, or the ODI
Yes,
regulations.
yes, yes, yes. So I think there is a paragraph, B1.1. If you have it handy, I can refer it to you. But
Okay.
just
We'll share it with the students later.
yeah, but so I'll just point out the relevant paragraph to you. Yeah, so the relevant paragraph is B 1.1.
Yeah.
Of the ODI Master Circular.
We can go through it.
Yeah, so I mean, this says, we can go through it later, but all this says is, that it allows you to issue corporate guarantees on behalf of uh, first level step down operating JVs set up by, operating JVs and stuff like that. And there has been a clarification and all that. I mean,
Okay.
in simple terms, there are two levels of intercorporate financing which is allowed in the form of guarantees under the ODI Master Circular. So one way of,
Okay.
I mean, so either we could read 186.1 as saying, look, if the ODI Master Circular allows something, then this should be consistent with that, and read it together. Or we can say that, no, sorry, 186.1 is separate. It's only investment, and doesn't deal with, loans and guarantees. So I'll be more
Okay.
inclined to look at it along with the ODI circular, uh, because I don't know, it just seems more practical to look at it if one regulator has allowed it, especially from a foreign exchange point of view.
Right.
Okay, so I will just so briefly, so that are some of the sort of nuances in 186. Now 185. So 185 is. Shall we just talk about
Yeah.
185 now?
Yeah,
Okay.
yeah. We'll quickly go through the director loans aspect.
Yeah, 185
Yeah,
is
Prashant.
yeah. I mean, is essentially talking about intercorporate loans when there are common directors between two companies, and when
Yes.
it was introduced in the Companies Act, this section created a lot of problems, for day-to-day business, because it completely prohibited any intercorporate loan where you had common directors. I mean, as as a matter of practice, if there is a promoter group, it is very common to have the same set of directors, uh, through a network of group companies.
Right.
And there's a very practical reason for this, because over a period of time, these are people whom the promoter trusts, as people who know his business, who understands the promoter's growth prospects, who understands his priorities. So he trusts this bunch, and typically you will find the same bunch of people, functioning as common directors in a number of his group companies, because they understand the ultimate objective of the group and the business, and it's a very common practice. So when 185, when it was introduced, it completely debarred intercorporate loans where there were common directors between two companies.
Right.
So now, subsequently, again in the form of the rules have provided some, some leeway, and I will just take you to the specific rule dealing with it. It is Rule 10, which I'll just read out. So it says any loan made by a holding company to its wholly owned subsidiary, or a guarantee given, or a security provided by a holding company in respect of a loan made to its wholly owned subsidiary is exempted from the requirements of this section. This is the first clause one. Clause two says any guarantee given or security provided by a holding company in respect of a loan made by any bank or financial institution to its subsidiary company is exempted from the requirements under this section. Then there is a
Right.
proviso which says that provided that such loans under subrules 1 and 2 are utilized by the subsidiary company for its principal business activities. So what 185 has done is it has created a small window, where in the case of, again, the relationship is, between a holding company and its wholly owned subsidiary, uh,
Right.
then then any loan or guarantee can be given even though you have common directors between the two company. So
Right.
this helps. Of course, the challenge is that this is. Interestingly, let me just spend some time on this. So 181, 185, Rule 10.1 relating to 185 allows you to give loans to any wholly owned subsidiary, or uh, to any wholly owned subsidiary,
Right.
right? So let's put it differently. So if you have a wholly owned subsidiary today, and if you have common directors,
Right.
I can give a loan or a guarantee, or security.
Right.
Okay. Uh, But the second section, it says that, but if I have a holding company and a subsidiary, I can give only a guarantee if I have common directors.
Which part is this?
So this is rule 10(2).
Yeah, yeah.
Okay,
Right,
so rule 10(2). So what it allows you to do is, if you have a holding company and if there is a subsidiary and the subsidiary is taking a loan, you can give a guarantee, in favor of that, even though you have common directors, but you cannot give a loan. So loan is
right,
allowed only to a wholly owned subsidiary, but if you're just a subsidiary, then only a guarantee is allowed.
right,
So again, what this has done is, this has given some I would say breathing space to corporates who are functioning under 185. So they can set up these companies and provide intercorporate loans, even though there are common directors between these companies.
right,
And the list of sort of directors or interested directors, is fairly large. So it's that it's a long list, so it's very difficult for a company to overcome the list of interested directors as defined in 185, unless they set up a wholly owned subsidiary or a general subsidiary.
right.
Just to step back, so what these two sections do is, one is, so they are now applying the law to even private companies,
Yes,
which wasn't the case with the old act.
right,
And the second thing is, they're applying the law to investment, two layers of investment companies, again,
right,
which wasn't there. Uh, so the and remember, I just wanted to clarify that these are two layers of investment companies and not operating companies.
right,
So largely, this has been done from a, I would say there are two three aspects to this. I think one is from a corporate governance point of view. They want to make sure that there is liability attached to the main promoters, and when you lift the corporate veil, if something goes wrong, then you can have easy access to the promoters or the promoter companies, in case you want to attach liability to these companies.
right,
I think also the second thing is, just from a corporate governance, or from a sort of a cleanliness cleanup point of view, you want to make sure that there is transparency in who's running these companies. You don't want multiple layers, and you want, suppose, typically these companies are, if they are run by people in public life, then you want disclosures to be made on who's holding which company. And so some of these, by reducing the number of investment layers allowed, you're bringing greater transparency into the system.
right.
Yeah, so this was, I think, broadly, sort of just a summary of what these two
Intercorporate
provisions are
loans.
doing
Yeah,
today.
right,
Yeah. So
right,
they're giving you some. Obviously, they are more stringent now, but they're also, there's a way to sort of. There's more clarity now, and there's a way to do business, and it's also something which companies are now realizing on what they need to do and how they can do it.
right. Understood. So, should we move on to the project finance areas?
Sure. I yeah just so I thought,
Uh,
sorry, yeah, I'll just spend a minute
yeah, yeah,
more
please.
on, so I just wanted to, so also one should look at the ODI master circular on what is allowed and what is not allowed to be provided by group companies. So along with the Companies Act, you will need
Right.
to look at ODI Master Circular, which will deal with the applicable law,
Right.
and you'll have to read these two together and make sure that they work for the company from a business point of view.
Right.
Sure.
Do you have any note, Prashant, that we can circulate, or like, a handout with bullet points, just summarizing this, or maybe a firm's, internal knowledge sharing note, which we could circulate with the attendees of this webinar on this area?
Yeah, we can. I mean, I don't have anything handy, but I can.
Just a summary.
I can prepare something and maybe send it shortly.
Okay.
We don't have anything handy because some of this is fairly complex, and we haven't really
Okay.
prepared anything unless a client requires it. We have not prepared sort of any straightforward note.
Right,
But
right, right.
but I'm happy to share something subsequently.
Sure, sure. That will be wonderful, Prashant. Uh, okay, we can move on to the project finance aspect of the webinar.
Sure,
For
sure.
quick reference, I will. Okay. For quick reference, I can display a project finance documentation structure on the screen for the benefit of our students. So just give me a second. So yeah, I have displayed a project finance structure on screen. It will be good, Prashant, if you can help to the participants. And firstly, let's just give them a basic idea of what is project finance and
Yeah.
in what context we're talking about it here.
Yeah. Can you? Is it possible to generally spend a minute on the other chart with dealt with funding options?
The funding options, yeah,
Yeah.
sure.
Then I can just lead into this chart then.
Okay, that's the one. Okay, I can do that. So here's the chart on what are the funding options that a company has. Sorry, one second, I'll remove the highlights. Yes. Okay, no, it's not coming on screen. Is
Yeah.
it clear on screen?
Yeah. It's fine. It's fine.
Yeah.
Yeah, I just wanted to spend a minute on this. So, see, when a company needs money, where does it go? So these are the people who participate in uh, in providing money to a company, right?
Okay.
So just to, if you look at the top of the two guys who are there on the top are basically the sponsor or the promoters themselves, who provide equity typically, and to the left of it are the other guys who also provide equity, whom we popularly call private equity. So
Right.
they look at now the why do we look at equity differently is because their interest in the company is different. So one is that it could be, for example, private equity interest is fairly short term.
Right.
It's not going to be 20-25 years. They have reasons to get in. They may want management control. So there are a number of factors. They'll want put and call options at a specific price. So one when a business has to be set up, in the promoters will say that, look, so if it costs 100 rupees to set up a business, typically 25-30% has to come from the promoters, and out of that the promoter may not have all that 25-30%. So he'll go
Right.
to guys who are similar to him. He'll go to private equity guys or mezzanine equity or all these chaps and say, look, you give me some money, and I will give you the same rights like a promoter. So you'll
Right.
have veto rights. You'll have management control. It'll be like you are running the company. Some investors may say, okay, I want to run the company. Some may say, no, sorry, you run it, but just let me know if there's something important I need to look at. So the
Right.
different kinds of investors, but that is where sort of equity plays a role in funding a company.
Okay.
The next item is, if you look at the bottom of the chart, there is foreign loans and loans from Indian banks. So in every business, I will typically, unless we call it doing business on your books. It is very normal to take a loan either from Indian banks or from foreign banks, or intercorporate loans, which we just discussed, as a form of funding that company, because the company
Right.
needs money, and these are the various sources of loans which are available from different players in the market who will fund that company. Loans along with preference shares are essentially long-term instruments. So a long-term view will be taken by the funders saying, okay, I'm not going to make money today. I'm going to give a loan which will be there for 10 years or 15 years. And subsequently my business model is different. So I'm going to get some interest from this company, and as it goes along, I'll make a profit maybe in the ninth or 10th year. So the business model of a loan is very different, and the company typically will look at a combination of one or more of these funding options to go ahead and start a business.
Right.
Okay, so I just wanted to spend a minute. So now we can just get into the
We
project
didn't
finance.
discuss. I just had a couple of questions. Sorry to interrupt, Prashanth. One was about intercorporate loans and preference shares. We didn't explain that. We said
Yeah,
okay that
yeah.
preference shares are long-term funding options.
Yeah, so
That's yeah.
typically, yeah, I mean, no, this is just I'm just setting out at a very broad level what are the some of the instruments which we see.
Right.
Obviously the preference shares will give you a preferential dividend over many years, and again, you
Right.
have a concept of cumulative and non-cumulative preference shares.
Right.
So at the end of maybe 20 years, you may have a right to convert it to equity, or you may just pull out your money and go. But these
Right.
are all different structures for bringing money into a company.
Yeah.
So now, for example, preference shares, if they are non-convertible, then they are treated as debt, because they are as a loan. So it is taken back after 15 years, and so FEMA regulations and all will treat them as debt. So these are all sort of uh, what do you say, details which we can refer to
Right.
subsequently.
Right. In terms of the cost of funding, according to you, what is cheaper, equity or debt, or is it uh, relative to the promoters? Whether they value control more or whether they value, you know, paying out a certain amount of profits as interest.
See, it's very difficult to. I mean, okay, let's. I think equity, for example, promoter equity may be cheaper than private equity, because private equity will extract, his own share of, sort of his
Contractual
pound of,
right.
yeah, his pound of flesh for bringing in equity, and he'll want all the rights as an equity holder.
Right.
Right. Now, intercorporate loans obviously will be cheaper than going to the market, because you may have the ability to have a low interest loan from your group company, say at maybe 5 or 6%, compared to if the market is at 12 or 15%. You may just take a loan from a group company. And the challenge is that how much can the group company lend? Because for each business, the group company cannot act as a lender, because it has its own business to do.
Right.
Right, so there will be a sort of a sort of cat and mouse game which will go on. Now, as far as foreign loans and Indian loans are concerned, it's a interesting question, because this is what the RBI does on a day-to-day basis. So
Right.
there'll be a phase when foreign loans will be cheaper, and everybody will go and get foreign loans.
Right.
And there will be a phase where RBI will make sure that the interest component on foreign loans is not very attractive, and sort of make sure that Indian banks can lend to these companies.
Right.
So There are a number of factors which play a role in funding. It's also in India, typically it's also evaluation of the promoters, and to give you an example, a
I had a
foreign.
question here,
Sure.
Prashant. So RBI links the amount of interest to be paid back by an Indian company to a bank. It caps it, right? It puts a ceiling on it because foreign exchange is going out.
Yes, yes, yes.
So and the ceiling is, let's say, a few percentage points, would be between like 2.5 to 4 or 5% above the interbank rates, in the interbank market in London. Now,
Yes.
those rates are extremely low as opposed to a commercial loan in India, which would be anything between 13 to 18%. These loans, would be between 2 to 4% maybe, and if you add the ceiling amount, even then it would probably come up to 8%. So in any case, we say that these loans are much cheaper.
You mean the foreign loans?
Foreign loans are much cheaper than Indian loans for that reason, is what our guess would be.
No, no, you're right, but there is a catch to it. The So what RBI does is it knows that the foreign loan is cheaper, but the amount of interest you can pay on it is capped, and the amount of fees and other things you can pay on it is also capped.
Okay.
So what happens is it's not very attractive for a foreign bank, uh, to lend too many of these loans to the Indian market,
Okay.
right? So while the loan itself is cheaper, there are a number of other catches. For example, we call it the all-in cost, which includes the interest, or any currency payments or any
Right.
indemnity payments. So anything which you have to pay on that loan is capped at 8% or 9%, which makes, so see, the foreign banks, they don't want that cap, because when they are funding a project in a country, they want to uh, sort of take least risk and get maximum money.
Right.
But if there's a regulation which restricts that, then it doesn't become that attractive for them.
Right.
So yeah, so we could just then talk about the structure a bit, the project finance structure.
All right. Before that, I wanted to also compare the cost of equity versus debt, which we did not do. We compared the cost of different kinds of equity, and we
Right.
compared the cost of different types of debt instruments. But what about equity versus debt?
See, equity is always costlier than debt, because equity is a short-term option.
Right.
So the now, to give you an idea, the return on equity, which we call the ROE, or the internal rate of return,
Yeah.
for and when we talk about equity investors, they typically will expect. I mean, this is just a rough benchmark in the industry, but typically they will expect, say, 20 to 25% return on equity once the project starts functioning.
Right.
Right? So what's left in the kitty of the promoter or the company is that much less, because the cost of equity is a lot more. Now, if you compare that to the cost of debt, which may be 8% or 10% or 12%, and plus if you have 10 years to pay that back, debt is always a lot cheaper.
You're looking at it from the point of view of what if the private equity investor makes the kind of return he does make. But in most cases, these are merely paper rights, and private equity investors may be taking, hybrid securities which are likely to convert to equity, which means they are taking risk
Yeah.
and, taking back the sort of return in terms of a high interest rate, or which or return which is equivalent to high interest rate will not be possible if the company makes a loss. They will also lose money,
Yes,
unlike
yes.
an ordinary lender. However, the advantage they have is they have much more control over the company. The promoters have less control over the company at the same
Yeah,
time.
no, to answer your question, I mean, this is like, so to give you an idea, suppose we are looking at promoter equity,
Right.
right? Promoter equity will we can say will always be cheaper, because it's on the books of the company, and the company doesn't have to go outside to borrow any money.
Right.
right? So from that point of view, if a promoter invests this money and doesn't expect returns for the next 5 or 7 years,
Right.
then it definitely is a cheaper option. The moment you borrow any money from a third party, whether it's equity or debt, it becomes costlier than your own money,
Right.
right? So the challenge is not that. The challenge is, why would you as a promoter put your own money in a project,
Right.
right? The normal sort of business thumb rule is that you may put 25-30%, but typically you will borrow the balance because you don't know how this project will perform, and you don't want to put all your eggs in sort of one basket.
Okay. Interesting. Uh, Thanks, Prashant, for this, for helping us compare the cost of different kinds of funding options. Let's look at now quickly project finance structure. Uh, Before we go into it, let's see how is project finance different from ordinary kinds of finance, and when is somebody typically looking at project finance? So a project finance structure is represented on the screen. As you see, there are a lot of parties involved in this, right from an SPV or a special purpose vehicle, which is going to carry out the project, which is in the center of this diagram, to Indian banks, foreign banks who are lenders, promoter groups who contribute equity, and private equity investors, and various government authorities. Okay, so I'll leave it. I'll ask Prashant actually to explain this to us, and explain how project finance differs from conventional kinds of finance, and to explain this chart on screen.
Yeah. So just to spend a couple of minutes. So in a project finance, what happens is that uh, the vehicle which undertakes the project, does the project on a non-recourse basis to the promoters. So this becomes a very
Can
important
we
tool.
explain the meaning of this, Prashant?
Yeah, I'll just tell you. See,
Okay.
so suppose, so suppose, I'll give you an example. If tomorrow, um, Reliance wants to do an airport project, it is very easy for Reliance to set up to sign a check for 1 billion and do an airport project, say in Delhi.
Right.
That is easy. They just can sign the check. They have the money in the bank, and they can do the project and start the airport.
Right.
But so that is or Reliance can go to a bank and say that, give me, like we just discussed in the previous structure. So I will put 25%. You give me 75%. I want to set up this airport. So the bank will say, that's fine, I'll give you 75%. But if you are setting up this airport, I'm very happy, because if you don't pay, then I have the whole Reliance group of companies to go after and attach their assets and take security.
This is in the ordinary case.
In the ordinary case,
Yes.
right? Now we come to a project finance where Reliance says, no, 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 sorry, I don't want to do this project on my balance sheet, because I have 200 businesses, and I don't want the liabilities of one to get attached to the other.
Right.
So I set up a separate company or a project vehicle which will implement this project. If you want some support from equity, I will fund it. But tomorrow, that whole cash flow, and whatever the company gives you as security, uh, is that companies alone, and you as third parties, whoever you are, whether you're equity holders, your banks, you're the government, you're the contractors, whoever you are, you go and ask that company for your money if things go wrong. Don't come to me as Reliance, because this project is non-recourse to me. You don't have any further recourse to me. It is only to the project company. So this is the fundamental principle of a project financing.
Okay. Just a quick question there. Don't lenders ask for promoter-backed guarantees or corporate guarantees, which once again expose the parent company to similar kinds of risk? Or does it still help in containing the risk in some way,
Yes,
despite
no,
these kind of
you're right.
guarantees.
See, so you're right. So there is no fixed formula, on what the lenders will ask or not ask. But it all depends on the viability of the project. Now, typically, even if the promoters are giving some form of a corporate guarantee and things like that, it will never be for the full amount. It may be
Right.
for part of the amount, or to fund some particular asset, or something coming from abroad, or some big turbine or something. It will never be for the full project, because then the promoter will say, then why do I need you? I'll just do it on my books.
Okay.
Okay, so now so I just spend a minute on. So this is the various. I mean, some of this we have already discussed. So the if you look at the top part, we're looking at people who will fund this project.
Right.
So you have the banks on the left, and you have the equity guys on the right. So that is where you will get your money from. And then you have the government. Obviously, you need to deal with. And in India, you have sort of so many levels of government you need to deal with for your innumerable number of clearances which you need for a project. Uh,
Right.
so the concession authority plays the role because he's the one who's granted you the project. And
Just
then
one
you
second. Prashant, let me just zoom this to the right size. Yeah, 1 second. Sorry. I'll just display the chart again. Yes.
yeah. Uh,
Yes, Prashant.
yeah. Now so let me just um, you know let's just understand the just spend a minute on understanding the commercials of the project.
Okay.
Because see, if it costs me 100 rupees to set up a project, now to give you an idea, 25% will be equity, and the balance 75% will be loans.
Okay.
Okay. Now in this chart, so that 75% can come from the Indian banks or the foreign banks, and that 25% will come from the promoters or some private equity guy. Okay.
Yes.
Now, typically in most of these projects, the 100, the sort of the 100 rupees which I have, about 80 to 85 rupees will go to pay the contractor,
Okay.
who is represented as the EPC guy in this chart, right?
80 to
Now,
85% off.
of my project cost.
Okay.
So typically 80 to 85% of my project cost will go to pay the contractor.
Okay.
Okay. And this guy has to be paid. See,
We have not represented him on this chart, right?
here, contractor, EPC, the guy below.
Yeah, yeah, on the left.
Yeah. Okay.
Yeah, so he's going to be a third party.
Yeah. No. The interestingly, the contractor has to be paid even before the project starts making money,
Right.
because he's the guy who's going to build your project and then go home,
Right.
right? So you need, so what is your cost of funding and financing? Effectively, 85% of that is going to pay this guy even before your project is going to make money.
True.
Okay. The other guys, now you have the what we call the O&M guy, and the guy who provides technical assistance and all, can all get paid after your project starts making money.
Okay.
Okay. Now the question is, where are you going to get this money from?
We just talked about either the sponsor company, that's the promoters giving
No, no,
equity
no. To,
and
no,
loans.
no. What I
No.
mean is, once the project is up and running,
Right.
you need to make money to pay off all these guys, right? You have taken money from.
Yeah.
So where you going to get that money from?
So you'll have to charge the users of that project.
Yeah. So they are represented by the customers.
Okay.
Okay.
They may run into millions, right?
No, it depends. I mean, if it's a large power project, you may just have one customer. You may have many customers. If you're a phone
Okay.
company, you'll have lakhs of, telephone, mobile users. So if you're an airport, what do you say, operator, you'll have all the passengers are paying your UDF fee. So there are different models. There is no standard model. But so what happens in a project finance structure is that today, if I have to give you 100 rupees,
Right.
right, I have to do my maths and make sure that the customers who will pay for that project can generate more than 100,
Yes.
because otherwise the project makes a loss.
Yes.
Okay, now the reality in India in many infrastructure projects is that maths has gone terribly wrong.
Okay.
So a number of these guys, instead of getting paid 100, are getting paid 50 or 40 or 20 and all that.
Okay.
So which is why there is a huge problem with, so when you go back to the bank is saying, sorry, I don't want to fund your next project because I don't know, I've not even been paid on your previous project.
Okay.
Okay, so now so we get into now the guy below, who's the more important guy. So below the customer,
Right.
if you can just,
Below the customer.
yeah, yeah. So this guy is the main guy who determines how much money everybody is going to make.
Right. Regulator.
Okay, the regulator. So these are the typical participants in any project. So give you an idea. So if the regulator says that so the cost of your project is 100, and I think that a reasonable profit is only 5%, so I think you should make only 105.
Right.
Right now, this is the commercial wisdom of the regulator. So there's nobody who can question him saying, no, no, I think my profit should be 110.
Correct.
Okay. Now, so who is happy if it's 105? Is all the customers are happy because they have to pay only 105,
Right.
right? Who is unhappy? Everybody else is unhappy because they are depending on this project to get paid, more than 105.
Understood.
So the constant tussle, after setting up a project is, how do I maximize my uh, sort of cost analysis and put forth my best sort of foot, in front of the regulator.
Can we discuss some examples of projects and regulators to just understand this problem and appreciate it better? For example, in case of a power project, we may have the Electricity Regulatory Commission
Right, right.
fixing
So,
tariffs.
yeah. So to give you an idea, so I'll give you a recent example where on one of the Adani projects,
Right.
the for many years uh, the central regulator, the Adanis were asking for a particular tariff, in the project, which has to be paid by the users of that project, who were the various uh, electricity commissions, who were the users. So
Okay.
for many years they were denied that tariff, because the regulator said that we believe that whatever profit we suggest or we have suggested is what is fine with you. Anything more than that, we believe is not sort of feasible.
Okay.
Okay, so see what's happening is that, so in India, so either side, though you have a commercial and a market oriented project, you finally have a regulator sitting above all this, who has to approve how much money each guy will get paid, or
In
needs
case
to
of
pay.
Adani, which was the regulator?
This was the central electricity regulator.
But apart from electricity, say if you're building a highway or a port.
Yeah, no, no, I'll just come to it. So I'll just
Okay,
finish
okay.
that example. Now, recently, I think, about 6 to 8 months back, the central regulator actually allowed the Adani project to increase tariffs beyond what they were allowed previously.
Okay.
uh, and substantially increased them, and so everybody was very happy that they're going to get paid more. But the users of that power said, no, sorry, we don't agree with this, so we are going to challenge this decision, which is now before the Supreme Court.
Okay.
Okay, so one of the challenges I just wanted to point out in a project finance structure is certainty of tariff payments, or toll payments or user payments, which are enough to cover the cost of the project.
Right.
Okay, and that is a major challenge in all projects. So in some sectors you have a dynamic, regulator, or you have a dynamic market which will change in tune with the costs. In some other sectors, you may not have that sort of refined a regulator or a market. So there's a constant cat and mouse game which is played, in any of these structures.
Okay. Just one question now. These projects are referred to as public-private partnerships in most cases, right?
It There are different models available,
Okay.
where there is an element of public participation, either directly or through one of the government entities.
What would you see in a PPP? You would see maybe the project company being held equally by the government or something?
Yeah, so to give you an example, for the example, the airport projects, the greenfield airport projects like Hyderabad and Bangalore, for example.
Right.
So the International Airports Authority holds about, I think, 26% as equity in those projects,
Okay.
uh, and in turn, gets those returns over the lifetime of a project.
In that case, it's PPP.
It's one form. Like you said, the other form is, I mean, where you might be a government company who's implementing the project and may use private parties to implement that project.
Okay.
But essentially, you also, basically, you need to have some form of government shareholding. And when we say government shareholding, we mean public shareholding, because typically any government entity or body will ultimately is seen to be representing the public. So it's also dealing with public finances. So which is why it's referred to as a PPP project.
Okay. One more question. Can we distinguish between the concession authority and the regulator in case of the, say, in case of the electricity sector?
Yeah, see, the concession authority is also subject to the regulator at times.
Okay. And which is the concession authority if
Uh,
we
s-
take
no,
some
so
examples?
so typically, in the electricity sector, for example, the state government or the ministry or the department of electricity, whoever is handing out the concession to set up the project,
Okay.
who basically envisages the framework for setting up the project, will be the authority who's sort of you have to deal with.
Okay.
So to like, you'll have either for example, I mean, in states typically we don't have a single authority, but for example in ports, we have a port authority in some states,
Yes.
who will grant out, so who will have a model agreement and say, okay, whoever wants to set up this port, you sign this piece of paper with me, and then once you do it, you implement it, then you go and make your money and go get it financed. But if there's any problem, then you're subject to the regulator in that state. So both of us will go stand before the regulator if there's any issue with this project.
Okay.
Um, so yeah, so in some cases, yeah, it can be
So
different.
the port authority could be the port trust, for example. Is it?
Yeah, so in India, for example, the port trust controls the major ports,
Right.
whereas minor ports, you have a port authority.
Okay. This is
So
the regulator.
yeah, who might also function. See, that's what that function could be distinguished, or it could be similar depending on the sector and the project.
So sometimes the regulator and the concession authority could be the same.
Yes, I mean, for example, yeah, the example you gave, like major port trust. No, even in major port trust, no, no, the regulator will always be somebody who decides the tariff.
So in ports, for example, in the port sector, who is it?
So ports, you have, there is an agency called TAMP, that is tariff, what the tariff authority for major ports. It's
Okay,
called TAMP, who decides the tariff at which you can charge. The regulator will be the local port trust where you're going to set up the port.
okay,
Okay, so it could be Mumbai Port Trust, Calcutta Port Trust, Chennai Port Trust. So this will be the local port trusts, but they will all report to sort of TAMP, who will set up uh, the
okay.
tariff.
And the concession, and what do we typically mean by concession? It just means a grant to do something,
Yeah, it's just a license.
just a license.
Yeah, but it's not a. The only difference is it's a 200-page document which is supposed to tell you, what all you need to do.
Right. Okay. Sometime later, Prashant, we may like to discuss project finance documentation in more detail. We've just gone through the parties who are involved in a project finance transaction. This was very, very enriching, because project finance transactions are quite complex compared to ordinary financings. So I'll thank you for helping us out with that. And Prashant, I'll request you for another piece of help. If we have 10 more minutes, we could just
Sure, sure.
revise, maybe we could revise the first part. I think that was slightly complex, Section 185 and 186 of the Companies Act. We could just
Sure.
summarize it. Also, the problem was that we were not able to hear you clearly just on that part. After that, when we discussed funding options and the project finance documentation was fine. Okay, so there was some technical issue which was coming. It stopped after that. So if we can quickly revise it, in a capsule form, it will be very good. Do we have time for it, Prashant? Can we
Yeah,
take
yeah,
out
sure,
maybe
sure.
10
I'll
minutes?
I'll just yeah. So let me. So I'll
Thanks.
just.
Yeah, yeah.
Sure. So let me just go back to 186 to begin with.
Okay.
So I think so. The first thing we discussed was 186.1, which allows you to make investments only up to two layers of investment companies.
Right.
Now the exclusion to this, other than the proviso, is that operating companies are excluded.
Right.
Okay. Now investment company is defined in 186.13a.
Right.
It's basically an acquisition company or a holding company.
Right.
So if I'm an operating company, then I get the benefit of this section, even within India.
Right.
Okay. Then there are two statutory exceptions to which is provided in the proviso itself, which is uh, if I'm doing this acquisition in a country beyond India, and if that host country allows more than two layers, then I can go ahead and invest through two more than two layer companies.
More than two layers of companies. Right.
More than two layers, as long as the host country laws allows that.
Right.
Okay. Uh, so then now why is 186 important is because we just quickly dealt with what can you do in 186. You can either give a loan, you can give a guarantee, or you can provide security. uh, you can provide it to any person or any body corporate,
Right.
but the limits which are specified in 186 are 60% of the essentially we'll call it the net worth of the company, but in detail it's defined as the paid up share capital, free reserves and securities premium account, or 100% of the free reserves and security premium account, whichever is more.
Right.
So that means this is the limit up to which I can give a loan, a guarantee, or a security to any person or any other body corporate.
Right.
If I'm exceeding this amount, I need a special resolution.
Right.
Okay. So then we discussed. I
Now
just
these transactions, sorry, just one interruption. These transactions are typically not occurring between arm's length companies, unless it's a financial sector company like a bank or a financial
yes, yes,
institution.
yes,
But
yes,
this section becomes relevant instead where there are group companies
yes,
involved,
very yes, yes,
right?
yeah.
Okay. Let's proceed further on this.
Yeah. So then I just wanted to draw your attention to where the 60% rule doesn't apply. So if you look at the rules which have been framed for the purposes of 186, Section 186, which are referred to as the Company Meetings of Board and its Powers Rules 2014.
Right.
So rule 11 says that when can I overcome this restriction which is set out. So rule 11, just to reiterate, it says that when a loan or guarantee or a security has been provided by a company to its wholly owned subsidiary or a joint venture company, then
Right.
then no special resolution is required.
Right.
So I can exceed the 60% if I meet these requirements. I don't need a special resolution, and I can go ahead with my loan or guarantee in the case of these intergroup companies.
But if it's an investment, in that case, that company must be my uh, holding company only. It cannot be a
Yeah.
joint venture company.
Yes, only for investment, but loan there is no such restriction.
Right.
Okay. Now, the only restriction which is coming on this is not from a Companies Act point of view, but from an RBI FEMA perspective,
Right.
where the ODI regulations in the case of cross-border intercorporate loans caps the limit at 400% of net worth or $1 billion a year.
Right.
So this is coming from not the Companies Act, but another regulator. So as long as you're within those limits, you don't have any difficulties in the Companies Act.
Right.
Uh,
The limit was of $400 million.
no,
No.
400% net worth
Sorry. Sorry. Yeah.
or
400% net worth.
net worth or $1 billion.
Right.
Okay, so that kind of sums up what you can do with 186, and how you can manage your loan and guarantee sort of portfolio on an intergroup basis.
So ODI regulations do not in any other way restrict this part.
No, so there are, for example, in terms of levels of subsidiary companies, only two levels are uh, uh, three levels are permitted in some cases.
Okay.
So there are restrictions. Otherwise, sorry, two levels are permitted under paragraph B, 1(1), which I pointed out.
Right.
But by and large, there are no other restrictions other than the financial limitations.
Right. So how do we count these two levels? So it will be holding company, and then it will be the next investing company, which is the second level, right? And the actual operating company can be at the third level. This is how we interpret the
Yeah,
section.
yeah. No, so what has happened? Yeah, so 1 minute. So let me just because paragraph B.
Or 186, whichever way we want to interpret.
No, 186. 186 actually. See, all that you have to make sure is that your two investment companies are within India. Right.
Okay.
Once you're outside India, then the host country laws apply. And if the
Right.
host country doesn't require the first level company to be an investment company, it can be an operating company also.
Right.
So you can still go ahead and give that loan or guarantee as long as you comply with the FEMA regulations.
But what about domestic investment? So how do we
Domestic,
count it? Yeah.
yeah. So domestic, that's what. So I think the issue there is that then we come back to 186, which says, so again I'll just take you back to rule 11, which says what is allowed is only a wholly owned subsidiary or a joint venture company.
Right.
So the way I read it is that if you're not a wholly owned subsidiary, and if you can prove that you're a joint venture company either through shareholding control or management control,
Right.
then you will still meet the requirements of Rule 11, and you can go ahead with that investment, even if it may be more than two layers.
Right.
I think Rule 11 is quite
You can pass
helpful.
the 60% requirement, or you can even bypass the number of layers requirement.
I think you can do both. You can obviously pass the 60% requirement if you're a joint venture.
Right.
Now, since the definition of joint venture is quite wide, we don't have to have the immediate company. To give you an example, if I'm the holding company, I could have two layers of company below me and then invest directly in the third level. I would still technically be a joint venture if I have any direct shareholding.
Right.
So, I can use I can use rule level to my advantage.
Okay.
Okay.
Yeah. So, but in a normal case, so I would say that, you have holding company. Uh, yeah. In a normal case, I would say you have holding company, investment subsidiary one, and then the operating company. That's the two layers, right?
No, you're allowed two levels of investment company. So you could have investment company one, investment company two, and then the operating company
And where is the holding company?
on top of investment company one.
Okay.
So then you may not be able to give a loan to your operating company who is three layers below unless you are a joint venture.
Right. 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 All right.
Okay.
And yeah.
So now
And
just to yeah, shall I move on to 185?
yeah. 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 Sure.
Okay, so 185, like I said, was when it was introduced, it created a lot of problems because it was an absolutely restrictive provision. Now, with the help of the rules, there are certain avenues open for 185 to be used. So I will just take you to the rules.
Right.
So the relevant rules again are the same set of rules which are the company's meeting of board and its powers rules 2014.
Right.
If you refer to rule 10, so rule
Right.
10 says that any loan made by a holding company to its wholly owned subsidiary, or a guarantee given or a security provided by a by a holding company in respect of a loan made to its wholly owned subsidiary, is exempted from the requirements of this section.
Right.
And then any guarantee given by a holding company to its subsidiary company is also exempted from the requirements under this section.
Right.
So I'll just explain in practical terms what it means. So in the first case, you can have if you are giving a loan. So let us first understand what can you give under 186. You can give three things. You can give a loan, you can give a guarantee, and you can give some security.
Right.
Okay. Now what this does is, in the first case, if you're giving a loan, then if that loan is given to a wholly owned subsidiary,
Right.
or if a guarantee is given to a wholly owned subsidiary, or security is given to a wholly owned subsidiary,
Right.
then in each of these instances, if there are common directors between these companies, that the provisions of section 185 does not apply.
Right.
So this is the first instance where if I'm a wholly owned subsidiary and if I'm giving a loan, a guarantee, or a security,
Right.
uh, I can go ahead and do it even though I have common directors between my holding company and my wholly owned subsidiary.
Right.
Okay, now the second part which allows you is that if I am not a wholly owned subsidiary but I'm only a subsidiary. If I'm only a subsidiary, then if I'm only giving a guarantee or security,
Right.
and if I have common directors, then section 185 doesn't apply. Which means the other instrument which was allowed in the previous case, which is if I'm giving a loan, then section 185 is attracted.
Right.
Right? So if in an intercorporate situation, if the subsidiary is not my wholly owned subsidiary and is just a subsidiary, I can go ahead and give a guarantee, or I can provide any security, even though there are common directors in both our companies, but I cannot give a loan.
Right.
So this what do you say, window has been introduced by the rules, rule 10, recently, which enables companies to go ahead with their intercorporate fundings in certain cases, even though they have common directors.
Right.
Sure. So I think, yeah, that sums up 185.
Yeah, that makes it very clear. So just when we are considering a transaction between two companies, uh, firstly let's exclude the holding and subsidiary relationship. If we are considering two independent companies and a transaction between them, we have to first check whether there are whether there are common directors. If there are
Yes.
common directors, then 185 will kick in, which will prohibit loans. Okay. If there are no common directors, then only 186 will kick in, which has
Yes.
a cap on the net worth and which has a restriction on the layers of subsidiaries.
Yes, that's right. Yeah.
If, however, these are group companies or joint venture companies, then in the event there are common directors, we have to look at 185. If there are no common directors, then we will just look at 186 and see if they are excluded, if that particular transaction is excluded from the regulation. If it is not excluded, then we'll take a special resolution and carry this transaction out.
Yeah, that's it. Yeah.
Okay, great. Uh, I think that's good. That's great for now, Prashant. This actually clarified a very, very murky area of law. I think there were so many undercurrents and so many elements that were coming out of these two sections. So thanks a
Right.
lot
Right.
for helping us out with that.
Sure.
And if so, I already asked you a lot of questions in the middle of the webinar, and a lot of these have been articulated by our students. So it sort of went in a free flow. So if there is any other question, uh, we will be forwarding it to you, and our participants, all our students, you can send questions to our email ID at startup@ipleaders.in, and or SMS or WhatsApp them to 9717301797. We thank Prashanth Sabeshan for coming and taking this webinar for our students, and we hope to see him again in the future. Uh, Thanks, Prashanth, and stay tuned, everyone, for our next webinar. We will inform you shortly of the topic and date.
Sure.
Thanks,
Thank you.
Prashanth.
Thank you. Thank you very much. Thank you very much.